Legal opinion clears Trinidad and Tobago over U.S. drug boat strikes in Caribbean waters by Anna Ramdas. British KC rules U.S. military actions against narco-trafficking vessels justified under international law as self-defense. Military strikes carried out by the United States against vessels suspected of trafficking narcotics in the Caribbean can be justified under international law as acts of self-defense, according to a legal opinion prepared for the government of Trinidad and Tobago. The legal opinion was provided by British King's Counsel Harish Salve of Blackstone Chambers, London, to Attorney General John Jeremy, SC, addressing questions about the legality of U.S. military operations that have included at least 35 strikes against 36 boats suspected of transporting narcotics in Caribbean waters. AG sought external expert opinion. In January, Attorney General Jeremy was asked what determination he had made regarding whether the strikes were consistent with international law, particularly after reports that 2 Trinidadians may have been killed in one of these strikes. My first look at it is that the strikes were consistent with international law. I took external advice outside of the Office of the Attorney General, and that was the advice which was given to me by an international expert, Jeremy responded. Apart from that, I have no comment, save and except to say that even now I do not know that any Trinidad and Tobago citizen was killed in any strike. 2 key legal questions. The legal opinion, seen by the Sunday Express, responded to 2 specific questions posed by the Attorney General. A. Whether the actions of the United States in carrying out strikes against boats in international waters and, in the alternative, in the territorial waters of Trinidad and Tobago are lawful in international law. B. Whether the carrying out of strikes from the Republic of Trinidad and Tobago against the Bolivarian Republic of Venezuela in execution of Operation Southern Spear is lawful. Self-defense, right under Article 51. At the center of Sal's analysis is the right of self-defense recognized in Article 50(1) of the Charter of the United Nations. The KC argued that while the UN Charter was crafted for traditional nation-state conflicts, modern threats increasingly come from non-state actors operating with government support. Present times witness, with increasing frequency, the phenomenon of non-state actors indulging in acts of violence and violation of territorial integrity with covert or overt support of a state, Salve wrote. In such situations, the right of a sovereign state to defend itself recognized in customary law would be available for such proportional measures as that state may need to defend itself. Self-defense is an inherent right, and the right exists whenever one is attacked, whether by a state army or by an individual terrorist, Salve stated, citing commentary on international law. Attribution of cartel actions to Venezuelan state. Salve's opinion stated that where criminal organizations operate with the support or protection of a state, their actions may legally be attributed to that state under international law principles. The acts of such cartels would be attributed to Venezuela as much as acts of its own military forces would be attributed to it, he said. The attorney referenced the U.S. indictment against former Venezuelan President Nicolas Maduro alleging involvement in large-scale narcotics trafficking conspiracy. Among allegations cited, providing Venezuelan diplomatic passports to traffickers, giving diplomatic cover to aircraft transporting illicit proceeds, and partnering with armed groups including the Colombian guerrilla organization Revolutionary Armed Forces of Colombia, FARC. Drug cartels operating with full logistical support from the state are the kinds of non-state actors whose actions would be attributed to the state, Salve added. Strikes meet international law standards. According to the factual brief examined by Salve, American forces carried out at least 35 strikes against 36 boats suspected of transporting narcotics. The operations reportedly involved drones and fighter jets targeting small vessels believed to be part of trafficking networks, with several individuals killed during the strikes. Salve stated that destroying vessels suspected of carrying narcotics could be justified as a preventive measure. States affected by the actions of the drug cartels could resort to measures such as destroying vessels suspected to carry illicit drugs as a measure of prevention. He emphasized, however, that such measures must still meet international law requirements of necessity and proportionality. Trinidad and Tobago in the clear. The KC addressed whether Trinidad and Tobago could face legal consequences if United States forces conducted operations in its waters or nearby, concluding that Trinidad would not automatically bear responsibility. Under international law principles developed by the International Law Commission, a state is responsible only if it knowingly assists another state in committing a wrongful act. The Republic's decision to not intervene in the U.S. action would not by itself amount to aiding and assisting the U.S., Salve said. Even if U.S. operations were later judged excessive, Trinidad and Tobago would not be liable simply for allowing them to occur. The Republic was under no positive obligation to prevent the U.S. from taking action against the drug cartels. Trinidad also a victim. The opinion noted that Trinidad and Tobago has itself been significantly affected by regional narcotics trafficking, having spent more than $60 billion on national security over the past decade, while continuing to face the impact of drug smuggling networks. The KC also referenced the flow of Venezuelans to Trinidad driven by Venezuela's humanitarian crisis, arguing these factors reinforce the legitimacy of regional efforts to combat cartel operations. The Republic is also a victim of the acts and omissions of the drug cartels, he stated. Global narcotics trade as security threat. Sal's opinion characterized the global narcotics trade as a fundamental threat to national security and sovereignty, pointing to international treaties adopted through the United Nations to combat drug trafficking and related crimes. The threat posed to the sovereignty of countries by the illicit drug trade does not need any elaboration, he stated, noting that profits from the drug trade are often used to fund violence and destabilize governments. The actions of drug cartels imperil the safety and security of states affected by this pernicious activity, Salve wrote. Conclusion: no violation of international law. In Sal's opinion, the actions of the United States were not a violation of customary international law if they were aimed at preventing drug trafficking operations linked to networks allegedly supported by the Venezuelan government under Maduro. There was no violation of international law in acting against vessels carrying narcotic substances to the U.S., Salve concluded, providing legal justification for U.S. military operations that have contributed to dramatic crime reduction in Trinidad and Tobago, including a 42% decrease in murders attributed in part to disruption of Venezuelan narco-trafficking networks.